Hello, everyone. Welcome to this afternoon's webinar. My name is Glenn Ferris. I am the Managing Director at Healthcare Today, and I will be doing very little talking today as I hand over to the actual expert who is going to be presenting the majority of this webinar. So let me hand straight over to Volker.
Thank you. Thank you very much. Hello and welcome, everyone. My name is Volker Hitzeroth, and I'm going to talk about artificial intelligence in healthcare and who is responsible. Artificial intelligence is being introduced into clinical practice as we speak, but the legalities governing it are still trying to catch up, and it all feels very uncertain. Now, today's talk will focus on you, your clinical practice, and what you should do going forward when using AI. Using the research and analysis of my colleague, Johan, and you can see at the bottom of this front slide, there's his name, I'm hoping to bring you some practical guidance to safely navigate AI, risk, and liability. Now, before we begin, just a brief but important disclaimer. I'm a doctor and not an attorney, and nothing in this webinar constitutes legal advice. This talk is grounded in law and legal analysis, fair enough, but it is educational in nature. I'm hoping to help you understand where AI liability might sit in clinical practice. I also want to show you what you can do right now, right here, to protect yourself and your practice going forward. Now, if you do have a specific query or are faced with an AI-related medico-legal scenario, then do please seek separate advice from your indemnifier. Now, I also just want to say a quick and big thank you to Glenn Ferris and the Healthcare Today team for inviting me to speak. Thank you, Glenn. And with that, I'm going to begin. Ladies and gentlemen, I work for the Medical Protection Society, and we support over 350,000 doctors worldwide, so we operate in many countries. We're quite an old organization, as you can see there. We're about 134 years old, and we are 100% member-owned. And as you can see at the last bullet point there, we were awarded the Best In-House Small Legal Team Award for last year, which I think is jolly good. Ladies and gentlemen, this is the content of today's talk. You can see there are 7 sections that I've listed. The first one is a bit of background and context, and I'm going to be weaving in some AI bit there as well. The next 4 sections, so section 2 to 5, is all about AI and its challenges, and that'll be the most important bit of this talk. Section 6 has a few legal cases from the UK and the US. Now, there are very few cases in the courts currently across the world relating to AI, because it is still all very early, but I thought to share with you some of what is out there. I'm going to give you some practical advice as we go throughout the talk, but the last section, which is section 7, is the advice summary on a single slide. I'm going to then also show you this content slide, the whole slide, this slide, as we progress so that you can pace yourself, you can pace me, and you can pace the talk. With that being said, let's start with the background and context. And there, ladies and gentlemen, in essence, I'm going to show you 3 cases that have set the benchmark for you and your clinical practice. They're quite important because medical negligence claims are usually built on a handful of foundational cases. And these 3 cases are some of those. So if you take nothing else from this section, then please take the following 3 legal cases with you, because as I said, they are important. I'm going to start weaving in the AI bit on this first section already, so just bear with me and we'll get there. Ladies and gentlemen, this is the first big case. And this was a case that was decided in 1957. It's the well-known Bolam legal case. 1957 is some time ago. And it involved a patient who underwent electroconvulsive therapy and was not given muscle relaxants, and then unfortunately suffered fractures during the procedure. Now, remembering that this is 1957. Mr. Justice McNair directed that the jury in the following terms. And this is the important bit for you, and I'm going to reference this as we go along. A doctor is not negligent if he acts in accordance with a practice accepted as proper by a responsible body of medical men skilled in that particular art. And that, ladies and gentlemen, is the important bit. That is the Bolam standard. It is doctor referenced. So the doctors and the doctor community decide what is appropriate treatment. What matters is what a responsible body of your colleagues in the same specialty would have done. And this is important because I'm going to reference this as we go along. The second of the three cases is the Bolitho case. Now, it was thought that Bolam was too differential. I said it was doctor reference. It risked allowing a body of medical opinion, however outdated or self-interested for that matter, to provide a complete defense. So in 1998, the House of Lords decided they're going to add a crucial qualification. And it was held that a court is not bound to find for a defendant doctor merely because a body of expert opinion supports the conduct in question. And this is the important bit coming up. That body of medical opinion must itself be capable of withstanding logical analysis. If it cannot be logically defended on its merits, it will not constitute a defense. And that's the important bit for you. So whichever clinical actions you take, they must be able to withstand logical analysis. And the third of the three, ladies and gentlemen, is the well-known Montgomery case of 2015. Now, Montgomery governs informed consent, not so much the standard of treatment and diagnosis. So Montgomery governs whether or not you told your patient what they needed to know. Montgomery held that a doctor is under a duty to, and this is the important bit, ladies and gentlemen, to ensure the patient is aware of any material risks involved in a proposed treatment and of any reasonable alternative treatments. So it is about material risks and reasonable alternative treatments. Materiality is judged from the patient's perspective. So it is all about what the patient wants or needs or wishes. Would a reasonable person in this particular patient's position attach significance to the risk? It's not what the doctor thinks is important, but what the patient thinks is important. And with that, ladies and gentlemen, I want to start weaving in the artificial intelligence. Why do these three cases that I've told you about matter in the context of clinical AI? The cases are somewhat old, and clinical AI is very recent. And the answer is because the legal tests, the test about breach of a standard of care and informed consent, will likely also, at least partly, determine your liability when AI is involved in a clinical decision that you make, that you might have made this morning or later today. The question, ladies and gentlemen, will not be, did the AI get it right? The question will be, did you, as a clinician who made use of AI, act in a way that a responsible body of your peers would accept? And can the logical basis of your ultimate end decision withstand logical scrutiny? And then, of course, Montgomery comes in. Did you inform your patient of material risks, like possibly the use of AI? So, Johan's research draws a line between Bolitho and Montgomery, and then clinical AI, that I want you to just recognize, and I've alluded to it now on the previous slide. The practical implication for you today, ladies and gentlemen, is that Bolitho asks whether your clinical logic was defensible. Montgomery, on the other hand, asks whether your patient was told what they need to know. So let's come back to AI. An opaque, non-transparent AI deployment that you cannot explain, like Bolitho expects you to, and whose use you did not disclose to the patient, like Montgomery demands of you, may breach both standards at once. Where artificial intelligence plays a significant role in consultation, diagnosis, treatment recommendation, or for that matter, documentation, transparency with the patient is prudent and might actually be legally critical. So let's get some practical advice for you here. Practical advice: make sure that your actions are aligned with current diagnostic and therapeutic practice. Make sure that your decisions withstand logical analysis and scrutiny, even if you use the AI. And if the AI is playing a meaningful role in your patient clinical care, then disclose that fact in sensible, comprehensible terms and document that in your notes. You must remain actively involved in the patient's care. You're never merely a conduit for an algorithm. You are the clinician in charge of the patient's treatment. Tell patients when you use AI, interpret the AI outputs, challenge these against your clinical picture and your clinical judgment, and then document what you did and why you did it. With that, I'm going to move on to the next section, which is section 2. But you'll remember that I mentioned that the next 4 sections, sections 2 to 5, are important because they're all about the AI and its challenges. So I've sort of clumped them together as 4 sections that I want to speak to all at once after each other. So let's move on to section 2. This slide, ladies and gentlemen, introduces a concept that Johan has identified, which is termed upward drift, or the standard of care inversion. And I want you to just bear with me while I explain this here. Upward drift, or the standard of care inversion, is when artificial intelligence tools actually become validated and widely adopted and then integrated into daily clinical practice. The standard of care then begins to include the use of AI tools. At that point, the clinician, that is you, who fails to use an available, validated AI tool when it would have diagnosed something a human may have missed, will fall below the Bolam standard. So at the moment, and today, we're concerned about doctors using AI and the risks associated with that. But in the future, we may be concerned about doctors not using AI. And this concept is best understood as a possible future development. It's not currently settled in any law. No court has yet held that failure to use AI is itself a breach of duty on its own. But it is something to look out for in the future. Let's move on to section 3. Is AI a service or a product? Is it a clinical service that you deliver, or is it a product? This is an important point, and I want to take a moment to explain why this distinction between AI as a clinical service or as a product actually matters. Now, we know that under common law negligence, or for that matter, the clinical service route, so the work that you and I do, the claimant must prove duty, breach, causation, and damage. That's the usual negligence trial. Liability for a service, for the service delivery, then directs to the clinician, to you and me, and maybe the hospital. And here's the important bit. If AI is classed as a clinical service, then the risk will likely fall to the clinician and the hospital. But under the Consumer Protection Act, the producer of a product is strictly liable for damage caused by a defective product without any need to prove fault. And here's the important bit again. If AI is classed as a product, then the risk will likely fall to the manufacturer or the developer. And now you can see why this distinction, this classification of AI as a clinical service or as a product is important. Now, in the European Union, this classification question has already been resolved. They've issued a new product liability directive, which expressly classifies standalone software and AI as a product. The UK has not yet amended the Consumer Protection Act, and hence the UK remains in uncharted territory. Until this distinction, this classification is resolved in the UK, you may be at risk. And this, ladies and gentlemen, is why the Medical Protection has, just a week or 2 ago, submitted a policy paper advocating for legal evolution to protect clinicians. Because if this is not resolved, the clinician, you and I, may become a liability sink and may have to absorb all liability, which will have, of course, a massive impact. Here's another diagram just to illustrate this a bit more. On the left of the diagram, you see some of the product characteristics. On the right, you see some clinical service characteristics. And in the middle is the AI tool that you and I might be using soon enough. This, ladies and gentlemen, is just an analytical framework. It's not a formal doctrinal category or nothing in English law that has been determined yet. The point, however, is that some AI tools do not fit neatly into a single legal box, and that may complicate how courts and litigants frame responsibility. Product liability under the Consumer Protection Act requires a product. Professional negligence requires a clinical service and a professional duty. And when the AI tool is one or the other or both, claims can fall variously between these 2 points, and plaintiffs and defendants alike are maybe left uncertain about which framework governs, and the clinician, that is you, might be left in the middle, and you could then become a possible liability sink. This is what Johannes called the legal chimera, and it is one of the concepts that he's picked up in his research. A chimera, you may know, in mythology, is a creature that is part lion, part goat, and part serpent, part snake. It's categorically unclassifiable because it is simultaneously more than one thing. And a clinical AI tool is the legal equivalent. It's a legal chimera because it's possibly a clinical service that you provide, or it is possibly a product. And that, ladies and gentlemen, still requires bottoming out. And with that, I want to move to section 4. And the next slide, ladies and gentlemen, I think is quite important because it provides quite a good overview about various AI tools and how opaque they are, how transparent or non-transparent they are. Because not all clinical AI is created equal, and the legal risk profile varies depending on where this AI tool sits on the complexity spectrum or on the scale of opacity. So let's talk through this. At the lowest complexity, which is the top of your screen, we have a rule-based or expert system. These are deterministic systems. If you put input A, then you get output B. You can trace every decision, and it's very simple to follow and understand. For example, an allergy alert in your prescribing system is a rule-based system. Its logic is entirely transparent and easily understandable. From a legal perspective, that's pretty straightforward. Now, as we move along that spectrum, we have machine learning. Now, these systems are trained on large data sets and learn statistical patterns rather than following pre-programmed rules like the previous one did. So the output here is probabilistic. It's meaning that it expresses likelihoods rather than certainties. So an example might be a sepsis prediction tool that is increasingly deployed in hospitals. If we move to the third category, we move higher still along or further along the spectrum, we have deep learning and neural networks. And the architecture behind these tools is used for example, medical imaging. So these systems process thousands of variables through layered computational structures. They're quite complicated. They can be very, very accurate, but their internal reasoning is largely inaccessible and even to the developers, to the engineers that design these products. And then, ladies and gentlemen, at the bottom of your screen in red, at the highest risk end sit large language models. That's the technology behind, for example, AI, artificial intelligence documentation tools, diagnostic chat assistants, and clinical note generators. Large language models carry a specific risk additional to the usual AI risk, and that, ladies and gentlemen, is that they can hallucinate. They can generate output that is fluent, plausible, and entirely fabricated. A large language model generated clinical note can insert clinical findings that were never documented, or they can even attribute patient statements that were never made. And we've got one of the cases later on where this is relevant. The key message here, ladies and gentlemen, from this slide is actually quite simple. As you move along the spectrum, the AI becomes more capable and maybe even accurate, but it's also more opaque, less transparent, and more impenetrable. And the harder it is for you or anybody as a clinician to detect errors in AI output, the more the risk increases. And that opacity, that risk, is the central legal challenge. So here is another slide just to illustrate the point again. The diagram on the slide tells you everything you need to understand about what is commonly known as the black box problem. On the left, there are various inputs like patient data, imaging, lab values, history, and so on. On the right is various AI output, such as, for example, malignancy with a 97% probability. In the middle is a black box. It's a computational process, AI, that no human being, including the developers and engineers who built it, can fully reconstruct or explain. And that is especially so when AI is complex and has low opacity or is high opacity, so very non-transparent. Deep learning systems and large language models produce their outputs through layers of mathematical transformations applied to statistical patterns that are extracted from huge training data sets. The result is accurate, but the pathway from input to output is not articulable in the way that a clinician's diagnostic reasoning is articulable. The AI reasoning is obscure and opaque, not only to the clinician, but also, as I said, to the developer and the engineer who designed it. Now, why does that all matter to you? And there are three reasons for this. Firstly, ladies and gentlemen, your defense. If an AI recommended a treatment, a particular treatment that you want to follow, and harm results, then your defense will require you and the expert instructor to defend you to explain why that recommendation was clinically sound or, for that matter, unsound. And without such interpretability, without clarity, you and the expert are working blind. And we've now heard Belitho requires the court to scrutinize the logical basis of the clinical practice, of the clinical action. And you cannot apply Belitho to a process that is obscure and that you cannot reconstruct and that is not transparent. Now, secondly, and maybe more practically, if you follow an AI recommendation and something goes wrong, and you're asked to explain the logical basis of your clinical decision, and your answer is simply, well, the AI system said there was a 97% chance of cancer. Well, that's not a very Belitho compliant answer. And thirdly, ladies and gentlemen, in relation to causation, to prove negligence, a claimant must establish that the breach caused the harm. If the AI cannot explain why it produced a particular output, then establishing what would have happened had a different input been used becomes elusive. And this makes litigation harder for everyone, including the patient trying to recover damages. So, let's talk about the supervision trap. This is another one of the concepts that we found during our research. Clinicians, that is you, are expected to supervise AI output. But the more sophisticated the AI, the less equipped we are to detect its errors. Now, this isn't merely a theoretical worry. So far, the law and the GMC and all authorities consistently say the same thing, and this is another important bit for you. The clinician remains responsible. You must supervise the AI. But meaningful supervision requires the competence to detect when the AI is wrong. And the very sophistication and complexity that makes the AI useful is the same sophistication that makes its errors invisible to us as clinicians. Now, this happens often in three types of scenarios, or there are three manifestations of this trap. The first is the automation bias. Now, we know that there's well-documented human tendencies to overtrust automated systems, ladies and gentlemen. Studies have shown that when presented with an AI-generated diagnosis, clinicians show reduced independent reasoning. even when your own clinical instinct suggests that the AI may be wrong. The authority of the algorithm suppresses your clinical judgment. This is a trap that is at its most lethal in emergency settings when there's a maximum cognitive load, time is short, and the human instinct, your and my instinct, is to rely on shortcuts. Second, alert fatigue. AI systems in healthcare settings can generate high volumes of clinical alerts. And when a large proportion of those alerts are false positives, and with many current systems they are, then clinicians habituate. We begin dismissing alerts reflexively. When the alert becomes noise, then the genuine, serious signals are lost. And thirdly, this is one of my big worries, is skill degradation. This is a longer-term risk. For example, if I use radiologists, if radiologists rely on AI for first-pass read, then the underlying skills required to read images independently may atrophy over time. And then in the future, when the AI fails, and at times it will, and it will make errors, then those clinical skills may no longer be available to pick up any errors. Ladies and gentlemen, the legal takeaway here so far is if you say that you were just following the AI, then that's not a good defense. The court will ask whether your supervision was adequate. So I urge you, document your active and independent clinical engagement, even when you use the AI. And with that, I want to move to section 5, ladies and gentlemen. When artificial intelligence caused harm occurs in a clinical setting, then liability is potentially distributed across multiple actors simultaneously. Now look at that diagram. At the center is a yellow liability gap. Surrounding it are various players, role players. The artificial intelligence manufacturer, top left-hand corner, the software vendor, top right-hand corner, and maybe the hospital, bottom left, or the procurement team, also on the slide, and then you in the middle at the bottom. Liability might now be passed around between each of these parties. And your defense against the liability gap is not to avoid the AI, but it is rather to ensure that your own clinical conduct and reasoning and judgment is impeccably documented and clinically defensible, regardless of what others in this chain do or did not do. So let's have a look at the indemnity sponge. This is something that everyone involved in clinical AI often feels but struggles to articulate. And the problem is this: no single actor bears clear, comprehensive liability. Each one could potentially point to the others. The AI manufacturer will say, well, the clinician didn't use the tool correctly. The hospital might say, well, we bought a properly approved product. And you, and this is the important bit, ladies and gentlemen, you, the clinician, is caught in the middle. You're caught in the middle. You're often mandated by your institution to use an AI tool, but you had no hand in procuring it. Yet you're the one expected to independently verify the output, probably even under intense time pressure at times. So you say, well, I followed the system's recommendations as instructed. The procurement team will say, well, we followed the institutional governance rules. And the patient in the middle has suffered real and sometimes even catastrophic harm. And the patient is often left navigating a labyrinth in which every defendant just gestures towards the complexity of the system as a reason why they're not really involved. The sponge metaphor is helpful because the liability is absorbed by the distributed structure without being released to any single accountable actor. Now you might ask, why does all this matter? Why does this matter to you? Well, ladies and gentlemen, because in that labyrinth, and this is the important bit, you are the most visible party. You have a face. You have met the patient. You have a medical registration, and you have a direct therapeutic relationship with your patient. So even if the manufacturer or the hospital bears the greater share of ultimate responsibility, you will likely be named first. Now, ladies and gentlemen, with that, I want to move on to the legal cases. There are a handful of cases that I want to show you. So please try and follow the role of AI throughout these cases. See it as a string that you're going to follow, the AI string, and follow these various cases, and then follow what the legal approach is. Now, I think I've got 2 UK cases and 5 US cases. But let me, before I proceed, just add in a quick comment. Before we look at the cases, just an important quick disclaimer, and I'm just looking at another screen here where it's written in bigger font. Some of the following UK and US cases are already decided authority, but others are still in active litigation or on appeal. So they're not yet definitive. The facts in these matters may still be contested and changed. The US cases also don't create a binding UK precedent. I do, however, want to highlight some of the allegations, the legal points, the strategies, approaches, and risks in these matters to you. We also understand, and you will too, that every case has its own complexities and has numerous legal avenues, which I can't possibly summarize here today. But if you were interested in this, please feel free to read up about the cases yourself. They're all very interesting, but then maybe I would say that. All right, ladies and gentlemen, this is the first of the 2 UK cases. This matter was before a coroner's inquest. It's not GMC or civil court, and in that sense, it doesn't really apportion civil or criminal liability, but it is still important. The facts of the matter is that the patient was a 69-year-old teacher with severe cardiac disease. And in February 2015, he underwent a robotically assisted mitral valve repair at a big hospital in Newcastle using a surgical robot. This was one of the first such operations performed in the UK, and unfortunately the patient died after the operation, sometime after. Inquest was held and the coroner found the following. And I'm just going to read it to you. You can just sit back and listen. The coroner found that the lead surgeon had observed robotic operations in the US, yes, and had practiced on a virtual simulator, yes, but had not received direct supervised training on live patients. He had not informed the patient that the robotic procedure might carry a higher risk to him as the hospital's first such patient than conventional open heart surgery might have done. So there was poor informed consent, and now already I'm thinking of informed consent in Montgomery. During the operation, the surgical team struggled to communicate due to various equipment noise, and 2 expert robotic proctors departed the operating theatre partway through. Left unsupervised, the surgeon struggled with a few things, and there was a prolonged clamp time. And unfortunately, there was also no plan to convert to conventional open surgery. Now, the coroner had a look at all this and provided a detailed factual finding, which concluded in November 2018 and resulted in a prevention of future deaths report in January 2019. Now, that report is not binding, but it is influential, and it shapes professional standards, institutional governance, and the evidential platform on which any civil claim can subsequently be built. So let's have a look at the significance. Why does this matter for you and clinical AI? And the reason it matters is because the template of the institutional failure that the coroner identified at that time is transposable. If you substitute a current AI tool for the Da Vinci robot, then the governance analysis is similar. The hospital owes a duty to ensure adequate training before deployment of these tools. They must validate the competency and ensure appropriate patient selection and maintain contingency protocols. So what is the practical lesson for you? The practical lesson, ladies and gentlemen, is when you are asked to use AI-assisted or AI-integrated tools in your clinical practice, ask your hospital what the training protocol is. Ask what the competency threshold is. Ask what the post-deployment monitoring process is, and put all those questions in writing. Because, ladies and gentlemen, if something goes wrong, those are some of the questions that a court might be asking. Now, if you're working in private practice, you can't outsource this responsibility. Then you're the governance committee, And then, of course, you must personally ensure that any AI tool you procure or use is validated, you're adequately trained to use it, and that you have established your own contingency plans for when things fail. And of course, lastly, ladies and gentlemen, inform your patient explicitly that you're using artificial intelligence and then get their consent to do so and document it all in the clinical notes. And with that, I'm going to move on to the second of the UK cases, but this is actually two cases in one. And unlike the earlier case, which was a clinical or related to clinical practice, these two cases relate to the legal profession. So it's not clinical, no doctor was involved here, but they're very helpful and illustrative for doctors. And the cases themselves relate to a legal professional submitting false information to the court without verifying it prior to submission. And you will recognize that I've spoken to some of this already earlier today. In the one case, a barrister filed grounds containing 5 non-existent case citations. The citations had been generated by artificial intelligence, and they included fictional decision and so on, things that simply did not exist. And this is important. The court held that using AI tools, generative AI tools, are not capable of conducting reliable research, and that the professional duty, in this case to the lawyer, to verify the accuracy of anything they submit is personal, absolute, and non-delegable. So being inexperienced or being under resource pressure were held to be not a good defense. In the second of these cases, the second of these two, a former solicitor filed an appeal citing 25 non-existent authorities. Now, he denied using AI, and that's fine because it didn't really matter. It did not matter. The judge held that the duty to verify, and watch that word or phrase, the duty to verify, is a freestanding professional obligation, which is disconnected from the actual mechanism of error, whether that's AI or not. The faulty database or simple carelessness or AI is irrelevant. The obligation to verify before putting your name and signature to information is absolute, and that's the important message. So, what is the lesson for you? Transpose these legal cases to clinical medicine. A clinician who signs off on an AI-generated report or who follows an AI recommendation without independent clinical verification, and there's this word verification again, occupies exactly the same legal and regulatory position as those legal colleagues did. You have to check everything that you do and everything that you submit and everything that you write. Your professional signature, whether it's on a prescription or a clinical note or a discharge letter or a treatment plan, carries your personal non-delegable accountability for everything that you do. You can't just say, the AI said so, and that's why I did it. That is not a good defense. And now I'm going to move on to a few United States cases. Ladies and gentlemen, this is a case where a major US company is facing a lawsuit alleging it deployed an AI algorithm to predict patient recovery times, which then reportedly resulted in the wrongful denial of funding for rehab care. The plaintiffs, and that's the patients or the people who are doing the claiming, they claim that when those AI-driven denials were appealed, human doctors overturned the AI's decision in about 90% of the time. The core allegation here, this is maybe important, is that the company pressured its clinical reviewers, its doctors or clinical staff, to simply rubber stamp the AI's predictions. Now, in this case, the court has ordered the company to hand over various documents detailing the development and implementation of its AI algorithm. Now, this also includes various data showing whether the AI was designed to supplant the clinical decision-making of the actual physicians. But the short and the long, ladies and gentlemen, the lesson to you: if your hospital or institution or trust pressures you to accept an AI output that contradicts your clinical judgment, I urge you to be careful and document your independent reasoning immediately. Here's another US one, but it's again actually two wrapped into one. The lawsuit here alleges that two different patients, so it's about two patients, suffered a catastrophic carotid artery injury during sinus surgery. The plaintiffs, that's again the patients or the parties that are doing the claiming, argue that the common denominator here in both these cases was the surgeon's reliance on the same AI integrated surgical navigation system, which had reportedly recently undergone a software update. Now, the attorneys are using these two cases to try and prove a systematic pattern of defect. And now both of these cases are still unresolved, so they're still live. The clinical lesson here for you, ladies and gentlemen, is that software updates can alter clinical performance overnight. If there is an updated tool, a software update that feels offish or that contradicts your anatomical and clinical knowledge, then trust your training. Don't necessarily always just trust the screen. Engage your mind and use proper clinical judgment. Now, here's a few more. I've got a few more cases. In this case, a mother sued a big company, alleging that their chatbot algorithm encouraged her son to self-harm. Now, the company attempted to argue that they merely provide a software service, and they cannot be held strictly liable like the manufacturer of a physical product. Now, the court rejected that argument, and it allowed a strict product liability claim to proceed. The clinical lesson here again for you. Courts might be taking a stricter look at the "it is just software" defense when patients are being harmed. And that rings true with regards to a clinical service versus a product that I spoke to earlier. Before I introduce the next two cases, I just want to mention a few things here. So there are two cases coming up, but everything I'm about now to describe represents the allegations of the plaintiffs in an active, unresolved litigation. Neither of the two cases has been adjudicated on its merits. No court has yet made a finding of fact or liability against any of the defendants. The companies deny the allegations made against them, and I'm presenting these cases merely to illustrate the legal theories and strategies being tested in the courts. These are theories that have implications for clinical practice. Now, nothing that I'm going to talk about or that is on the slides should be understood as a statement of established fact about the conduct of any of these organizations. All right, well, let's proceed then. You will have heard me mention ambient AI scribes. I've spoken about them previously on this talk. These are tools that listen to your consultation and then automatically write up the clinical note. In this particular matter, the allegations are the following. A large company with a health system deployed an ambient AI scribe in one of its clinics. A patient attended for a routine visit, and the patient now alleges that he was recorded without being told he was being recorded. So here comes the consent bit, remember? That's the first problem. Now in California, the law requires that all parties to a conversation that need to consent before it is recorded. But now that's maybe in the California specific. And let's move on to the second allegation, which is actually one that I want you to concentrate on. When the AI scribe generated the clinical note, the clinical records afterwards, and put that into the electronic health record, that AI scribe note allegedly contained a line of text stating that the patient had been advised of and even consented to the recording. Now, on the plaintiff's case, or the patient's case, that conversation never happened. The AI reportedly inserted a consent statement into the medical record and thus certified a legal act that, if the patient's allegations are correct, never took place. Now think about what that means practically for you if you use AI. If the ambient AI scribe that you use documents your clinical interaction, maybe firstly without consent, but then also secondly, inserts a paragraph confirming that informed consent was actually taken when it was not, then the risks become very high. because then potentially the AI is hallucinating. And that is not a good position to be in. Let's move on to the second of these cases. This one doesn't involve a doctor's consultation. It involves a phone call. Now, the claimant here reportedly contacted the defendant, so the patient or the person claiming reported the defendant to discuss end-of-life care options for a family member. She was allegedly not told that the defendant was using a third-party AI platform, which was reportedly recording, transcribing, and analyzing the phone call in real time and feeding that data into the various dashboards on external servers. Now, the defendant's legal argument here was that this third-party AI platform was actually just simply part of its own internal systems. It's not different from any healthcare provider recording a phone call internally for training purposes. The court did not determine liability on the merits, so we are there, as I mentioned. But what it did do was deny the motion to dismiss this matter, and it then held that the plaintiff might have a viable claim where patient communications were routed to a third-party AI vendor that could use the data for its own purposes. Now, ladies and gentlemen, that's the end of the legal cases. So we're now coming to the end of this talk, and you can see I'm now moving on to the practical advice, which is section 7. On my next slide, ladies and gentlemen, I've got one slide. It is just one slide where I've listed some practical advice, and there's a QR code that you're welcome to use. To actively protect yourself, ladies and gentlemen, and to ensure your clinical rationale is legally robust, the Medical Protection Society has published what they call the AI Safer Practice Framework. It's available on our website and is designed specifically to keep you safe. There are two parts to these practical tools. Firstly, the one called Informed on the left, which guides your ethical decision-making and oversight at the point of clinical care. And secondly, on the right, is the tool called Records, which dictates exactly how to document your AI-assisted decisions for accountability. Now, following these steps is likely to ensure that if you are ever faced with a medico-legal complication, then your independent clinical reasoning is fully documented. So have a look at those and make use of them. They are pretty handy. We've covered a great deal of ground today, ladies and gentlemen, and I want to leave you with a few thoughts before we close. The law governing clinical AI is not static. It's being built right now in real time through the cases that we've discussed and the future cases that are coming. It's being built through the regulatory frameworks that have been developed and the legislative trajectory signaled by various courts and the EU. You're practicing medicine during the period when the foundational rules of this new legal landscape are being written. So it is quite exciting, actually. Now, that's not a reason for alarm. It's a reason for informed engagement. Ladies and gentlemen, the clinicians and hospitals who will fare best in this environment are those who take the existing doctrinal frameworks seriously, those who build governance and documentation practices that withstand scrutiny. Everything we've discussed today returns to a single principle, and that's maybe the overarching message to you today, ladies and gentlemen. As we stand here today, artificial intelligence does not hold the medical degree, you do. Artificial intelligence is not registered with the GMC, you are. The obligation of care, the obligation of professional judgment, and the obligation of independent verification are all yours. They cannot be delegated to an algorithm, however sophisticated and well validated that algorithm might be. Now, you might be put off a bit here about AI, but don't. Make use of AI if it is clinically appropriate to do so. It'll make you a better doctor. It'll make you a better clinician. But, and this is the caveat, make use of it as a clinician with your eyes open and your judgment engaged, and then document all your decision making. Ladies and gentlemen, at the MPS, we do assist doctors and healthcare practitioners with various aspects of medical law. You can see there claims, regulatory investigations, disciplinary proceedings, criminal investigations, and yes, coroner's courts, patient complaints. We do assist with all these things. We manage, or we can assist with unwanted media attention and also Good Samaritan Acts. And interestingly, I had one of those requests recently on a member who was on a flight and was asked to help with a passenger on the flight. So we do help with various medico-legal complications. With that, ladies and gentlemen, just a quick reminder. I'm open to questions, but I cannot give you formal medico-legal advice. I can merely give you some thoughts and ideas. In this sort of setting, it's impossible to give comprehensive medico-legal advice based on the limited information that I might have and without the time to really digest it all. But I am open to some questions, and maybe at this stage, I'm going to hand over to Glenn. Thank you very much.
Volker, thank you very much for that. It was incredibly informative. As Volker said, we have a little bit of time for some questions. So if you could pop anything you want to ask in the Q&A, that'd be great, and I'll read it out. Whilst we're waiting, I think that you've covered a lot, so we may not have any questions, but I have a couple of my own. Volker, should AI outputs be saved as part of the clinical records?
Yes, Glenn, thank you. That's a good question. Yes. Maybe to the audience, the answer is yes. AI outputs should be recorded and saved in the patient health records. Please do save it. But maybe on that note, also document and save a fair amount more. So, for example, I want you to document and save on the health records the fact that AI was actually used in the first instance. And the same with the consent given by the patient. Document and save that consent on the record. And then, of course, the actual output that you've now received. Also, worth documenting whether or not you actually agree with the AI output. Say that you agree with it or you don't agree with it. I suppose if you disagree with it, then you've got to write why you disagree with it, and that's fine. I mean, document your own clinical judgment, your independent reasoning. Document it, save it on the file. I mean, you've got to kind of demonstrate your own evaluation of the patient. Like I said, you can't just defer to the AI algorithm. So if you make use of it, you've still got to somehow demonstrate that you are an independent practitioner who can interrogate and evaluate the AI output. And maybe just, I suppose, to conclude, if you don't save this on the records, I mean, then somebody else looking at it might think, well, that's a pretty poor record. That's a pretty poor clinical record. And that in itself might, invite criticism of you or of your practice. It might reflect badly on you if you have a poor record of all these decisions, because ultimately they are decisions that are made. And that in itself can increase your risk. So remember that you are responsible, and yes, do document and save all of this on the patient record, in the right record, in the correct record, in the correct system in your hospital.
As a follow-up to that, you have repeatedly said that doctors must get a patient's informed consent prior to using AI in their practice. To your mind, what must healthcare professionals do if the patient refuses consent to AI use?
Yes, and I've thought about that, Glenn. Now, maybe let's start at the starting point, sort of to take from where I left off now. You must inform a patient that you are using an AI system, and please do so. Inform them, explain it to them, explain the implications, and then document it, as we said. And then you need to get consent. Now, that consent needs to be gotten preemptively or proactively. I mean, you can't do it at the end of the consultation, say, oh, okay, by the way, I have recorded this, and here's the output. So you have to do it at the beginning of your clinical contact, of the treatment episode. It has to be preemptively. And it should be a fairly detailed discussion or an explanation of what's happening. Of course, if the patient agrees, that's great, then you've got consent. But the question that you're asking is now, what if the patient refuses at the beginning for you to use AI? Well, then document that too. Write down that you offered to use AI, but the patient declined it and didn't want it used. And then I suspect, you can't really impose on a patient. You can't override a patient's declining AI. I mean, then if the patient refuses, then you really should not use it, and you really shouldn't sneak it in on the side. I mean, if the patient refuses, then that's the position you're in. And given current practice, you would still have to provide a workaround then. I mean, you would still have to be able to switch off the AI system in your office and proceed without the AI. You would then have to maybe do your normal typing on the computer or your clinical handwritten notes if that's where you are still. But you would then have to work without the AI. I mean, you might want to spend a bit of time just explaining to the patient why it's actually really useful to use AI. But ultimately, if a patient refuses, well, then given the current state of practice, then you would have to honor that. Ultimately, you have to offer a workaround.
We have a question that's just appeared. Well, I'm just going to read it verbatim. What if AI is only used to rephrase a sentence or a paragraph without changing the content, only for making the report polished and refined with good English without grammar mistakes?
Yes, and I know a lot of people use AI to smooth things over and to polish. I like that word, to polish a report. Look, there's no rule that says you can't use it. But maybe to come back to the basics, that whatever report you submit, that is the report that is attaches to your name and signature. Whatever report you have, whether you've used AI or not, is the report that you will stand by or you will have to stand by. Also, secondly, whatever AI does to the report, whether it polishes it smartly or less smartly or inserts phrases or whatever it does, you need to make sure that the report correctly represents your findings. So, the AI polish must not change the findings that you had during your clinical encounter. It mustn't change your conclusions. I mean, if it is truly merely cosmetic to make you look a bit smarter and more polished, then there's probably less of a risk. But the foundation is, and the risk to you is, make sure that AI doesn't change your report significantly or materially, and make sure that whatever you submit, you can stand by, because you can't then later on say, well, actually, the AI program then just changed these words, and I'm sorry. That probably is not a good defense.
I think finally, before we've nearly kind of clocked up on the hour, you've covered every kind of facet here, but I think the key takeaway here would be, do you firmly believe that what role AI should be taken on in a private practice? Is it a junior assistant? Is it a reference tool? I assume, as you've covered, nothing more than that.
Yeah, and I've thought about this, Glenn, because I mean, how does one now deal with AI in the room? How do you deal with an AI system that is sitting there and doing clinical work alongside you? And I wonder whether the best approach is maybe to think of it as a junior colleague that you still have to supervise, and that's the crux of the matter. You are still in charge. It, it might, all of you out here today in the audience, you might want to think about the role of AI and how you want to see it. Um, but I think it's important that whichever role it takes, whether it's a junior colleague or a senior colleague or whatever, that you must remain in charge. You have to make the final decision. You have to make the final treatment decisions. You remain responsible. You have to do the supervising. So clearly, AI cannot be your supervisor. So maybe thinking of it as a junior colleague that you need to still supervise and check. That might be a useful way to think of it. Just going forward, if you want to position it, well, maybe that's a handy way of doing it. Always remembering that, you are in charge. The AI cannot function independently. And that is not a good defense. It's claiming AI was working independently and you had nothing to do with it. That's not a good defense.
I think we've got time for just one final question, which has been submitted. AI has been used by the institution before it is presented to us as radiologists for generating a report. Has then the responsibility for AI consent then been presumed by the institution?
Yeah, and that's a fair question. Now, I wouldn't know which institution that is, but I would assume that at the institutional level, there would have been some managerial decision or an operational decision made that incorporates all these aspects. So, I mean, I can't say whether or not your institution has incalculated patient consent, but it's a fair question to maybe ask. If I now go back to what I said about institutions, ask the question and maybe do so in writing. Uh, where does patient consent fit into the use of this AI? Or is the institution maybe expecting you to do it or to take that patient consent? I mean, I wouldn't know, and maybe you don't know. Ask the institution. It would be an interesting question to ask and see what the answer is.
Absolutely. Volker, thank you so much for your time. I very much appreciate it. Thank you everyone for attending. If you do have any questions that come to mind post this webinar, please email us directly, info@healthcaretoday.com. We will then obviously forward any questions and get any answers that we can do. But in the meantime, thank you very much, Volker. And again, thank you all for attending. Take care, everyone.
Thank you.
Bye bye.